Oh, got the dongle. Okay, there we go. Okay, so let's get started. Here we are. Yeah, voila. Okay, good morning, everybody. Giviyat check al yedei hotza'ah lefoal. Collecting a check through what's called hotza'ah lefoal. Hotza'ah lefoal is to execute something, but I think what he's referring to here is some kind of collection agency. And Ha'im mutar lifnot lahotzah lefoal legabo check shelo kuvad al yedei habank. A check was not honored by a bank, and now I have the guy wrote me a check. It's a bad check, and now what are my options? So can I go to a collection agency? The Ha'im yesh baseh isur shel halicha le'erkaot. Is there a prohibition for me to do this because maybe this is like going to secular court? So Hamishna Omeret b'Masechet Bava Metzia. So let's take a look at the response. And again, I think that this is a shaila about using a collection agency to collect the debt. So the Mishnah says in Bava Metzia, Hamalvet Chavero, V'higia Zman HaPiraon V'lo Piro, that if a person, Ruvain lends Shimon money, the time for repayment has arrived, and Shimon has not paid the debt. Asr l'malva l'kachat chafatzim mehalovet tumurat hachov. The malva is not allowed to just indiscriminately take items of value from the lova, confiscate his items. Vafilu michutz lebeito, even if they're outside his home. Like, let's say I see, you parked your bike outside your house, so I just decide, well, you owe me $100 anyway. I'm just going to take your bike as collection. Not allowed to do that. The kol shekain sha'asalo lehikanes leveito lakachat mimenu chafatzim. And I'm certainly not allowed to just barge into your home and take items from your house. Kamosha kasuv batorah, bachutz ta'amod, because the Torah says that a creditor has to stand outside the debtor's house. And the debtor has the sort of the privilege of producing the security item, or is the item that is either used for security or for repayment. He brings that outside. V'darshu rabotenu b'gemara sham v'ha'ish hakavana bazeh sha'afilu l'shliach beitin ein rishus lihikanes lebeito shel haloi v'lakachas lo chafatzim. Chazal understand this to mean that even a marshal, a court appointee, cannot just barge into a person's house and walk off with his items. Aval mutar lishliach beistin lakachat mehalo v'dvarim shehem michutz lebeiso. But what a shliach beistin, if the court appoints someone to collect as a collector on behalf of the creditor, what a person is allowed, what that collector, what that marshal or bailiff, whatever you call him, what he is allowed to do is he's allowed to take items that are outside this person's house. Like, so he's not allowed to break in and enter his house, but what he is allowed to do if there are items outside his house, he can tow away his car if it's parked on the street. That is what a court-appointed collector is allowed to do. But umilvad hanal asur lemashkena talova b'dvarim sha'osim b'hem ochol nefesh k'mo shekasu b'Torah. But barring that, it's got to be someone appointed by the Beis Din. But in addition to that, it's also usher to take from the lova anything that he needs for his daily sustenance. As it says, Kamosha Kasuv B'Torah, Ochel Nefesh means for his daily food provisions. As it says in the Torah, Lo Yachavol Rechaim Varechev Ki Nefesh Hu Chavel. The Torah says that you're not allowed to take as security or to take as payment a millstone, an upper or lower millstone, because that's something that a guy needs to make his daily bread, quite literally. Okay. Okay. Lefize, im adam hilva lechaveru kesef v'hu shilin lo. And therefore, if a person lent his friend money and the friend has not yet paid, im hamal ve'yifna lahotza lepoal ve'hem yichnasu lebeit halo v'lokachad lo chafatzav. So it depends. If the collection agency will be aggressive, and maybe it's sort of like a repo agency, I'm not sure. If they're going to go into his house and take his stuff, which doesn't happen in Canada, I'm sure that doesn't happen here. The sheriff.
So you can sell the land on notice, the sheriff, or chattels or intangibles, like shares and cars and jewelry and stuff like that.
Uh-huh.
So it goes in bid.
Is he allowed to break into the house? Okay.
The pressure on needs to help, whatever.
Yeah, so probably not a very pleasant job to have.
We also have debt collection agencies also. We give the judgment to them, they take a third, and then they go ahead and hassle you until you yield, like they write letters that they put pressure on to get you. But there's also limits on that too. You can't harass people, so to speak. You can complain. You have to have a judgment. They could write letters pre-judgment if they want, but they can't do much else. If you have a judgment, you can give them the judgment, they'll take it and then take a third of what they collect, like doing all these other things, right?
Uh-huh. So not a very pleasant job. Yeah. So anyway, so Haim Yavru Ela Isser Shalo Tavo Al Beito. So if this collection agency will actually barge into his house and take his stuff, they would be violating the prohibition of you may not come into his house to take the security. And there are times when the lova really doesn't have any objects that he can use to pay back. And if they harass him or they pressure him, there's a violation in the Torah. Do not be an oppressor to a debtor who doesn't have the wherewithal to pay back. And this is true even when a Beis Din is involved and you ask them to be involved in the collection of your debt. They also have rules called misadrin lebalchov that we make accommodations for the debtor. So if you look in the footnote, first of all, we know that you're not allowed to be an oppressor of the debtor when you know he doesn't have. This is brought down in the Shulchan Aruch. Asur lingos et halova lifroa kishiyodea she'ena. You're not allowed to pressure the lova to pay back when you know he doesn't have it. Va'afilu laharat lo asur. And even just to show to him that he owes the money, you're not allowed to do. Mipnei shuhu nichlam biroto lemalveh. Or leherolo, just to appear before him, right? As we learned previously in a previous tshuva, that you're not allowed to sort of go out of your way to stand there in front of the malva because to embarrass him. And later on in that same siman in Shulchan Aruch, it says that every time that you appear before the guy, or that you ask him to pay you back, you're in violation of this law. Now, inyan misajin lebal chov. Now, what does it mean that the Beis Din has to make accommodations for a debtor? Shekasher Beis Din boim legavot et hachov mehalov. This means that when the Beis Din comes to collect the debt, me'ikar hadin hayitzarach halova l'shalim kol nechasav v'chafatzav kedei lifroa et chova. Really, the law, the letter of the law, would require the lovet to give up everything that he has to his name in order to pay back the debt. Aval, Chazal tiknu shemisajin lebal chov, but Chazal made an accommodation that we sort of have a little bit of rachmanus on a debtor. Dahainu shemashim lo chafatzav ha'ikariyim hamishamshim lemichiato, that we leave him his basic essentials that he uses for his regular sustenance. If you recall, when we were learning Hilchos Tzedakah, we were learning a little bit about that. We touched on this a little bit in the realm of, like, how poor does a person have to be in order to collect tzedakah? Is he obligated to sell off his furniture and the furnishings of his house in order to avoid collecting tzedakah? And I think what we had said there was that you're not obligated if you're going to be taking from the community fund. And certainly, let me just see if I remember this. If you're going to be asking individuals to give you tzedakah, you certainly don't have to sell off your assets. But I think that if you're trying to collect from a fund, then I think that we're a little bit more machmir, that we require you to sell off things first. But in any event, he says, V'zel lashon haShulchan Aruch. The Shulchan Aruch therefore says, Misadrin lebal chov. We accommodate the debtor. And what does that mean? We accommodate the debtor. Omrim lelove have kol hametaltalim sheyesh lecha v'lo taniach afilu machat echad. First, we tell the love, appear before Beis Din and show us everything that you own, without leaving out even a single needle. Okay? Vafilu klei ochel nefesh, and even your eating utensils. V'notli lo mehakol mazon shloshim yom kibeinoni sheba'ir. And once he produces everything that he owns, if he's got storage of food, we leave him with 30 days of food. Okay, uchsus yud beis chodesh. We leave him enough clothing for a year. Below sheyilbash bigdei meshi o mitznefet zuhuva. And it's not that we leave him the most expensive clothes, like silk garments or gold-plated turbans. Ela ma'avirin ota mimenu, v'notlin lo ksus haru'uy lo yud beis chodesh. But if that's all he has, we take that stuff, very expensive stuff, away and give him substitute clothing that's of lesser value, but it's just as long as he has enough to wear for a full year. Umita leishev aleha, and we leave him a couch that he can sit on. Umita umatza haruyim olishon aleim, and we leave him a bed and blankets and pillows that he can sleep on. Va'ayin shamod b'chol prate hadinim bazeh. He says, I refer you to the Shulchan Aruch, that you can see exactly what we leave. We have to provide a certain amount of sustenance for the debtor before we take everything away from him. So therefore, you have to be very careful about these repossession firms. If they're going to do more than what the halacha would permit, then it could be you're colluding with this agency. So let us continue. Sorry. Yeah.
Get that money back. They're just going to call him back down.
Right. Well, that's the problem. The problem is that what if the guy genuinely doesn't have any money? And all he has is stuff, let's say, in his house. So Fortunately, in Canada, no company is going to do that. They'll be convicted of criminal activity if they were to try and invade the guy's house. But apparently, in Israel, maybe they're a little bit, maybe these repo companies have more power to really go into a guy's house and start taking his stuff. Yeah, well, he may have a big screen TV. Right, right. Well, yeah, or either that, I mean, the debt is still outstanding. So if he has a reversal in fortune, hopefully, he'll be able to pay you back at some point. But
So this is not the guy's playing games. Got nothing to do with this. No one was talking about when he doesn't have the money.
if he doesn't have, but even if he does have, there are restrictions on what you're allowed to do to go into his house and take. Let's say he is playing games.
So that's where
So
the collection agency comes in handy.
yeah, as long as they're going to be, as long as they're going to comply with basic halacha, you can't go into his house and take his stuff. Yeah, right.
Otherwise, it would be fine.
Yeah, here in Canada it would be fine. So I just want to get into like what he's basically limiting any kind of collection agency from violating halacha. Yeah. The repo company. That's an interesting question. In that situation, it doesn't fully belong to the person whose house it's in, and maybe the law would be different. I'm not sure. I don't know. When you look at what the Torah says, Yotzei lechet ha'avot hachutza, the debtor shall bring out the object that's the security item outside. Who does that security item belong to? So that's really the question. If it was designated for collection, then in a sense it belongs to the creditor even before he collects it, in one sense. But I'm not. Yeah, right. But that's the point, is that the Torah says that even if you have every right to it as a creditor, you can't just barge into his house and take it. So I don't know how that translates into halacha, but I would imagine that a repossession company also has restrictions on just breaking and entering into a person's house. Right, and that's what we just saw. We just saw that over here. If the car is parked on the street, then right, or in the driveway. Or they can just wait for someone to click the. That's right. Okay. Anyway, ubifrat im shlichei ha'utza lepoal hem Yehudim. He says this is especially true if the proxies, in other words, if the people who are the part of the collection agency are Jewish, over hamalva alifnei iver lo titein michshol kivin shu machshol otam legabot shelo kedim. If their collection methods are against halacha, and you hire these Jews to do this, so then you hire Itzik and his cousin to go and no, not to break some legs, but just to go in through the mirpeset and to get the stuff. So that's you're causing them to sin. So you're being over on lifnei iver. Ubifrat shehem shluchim shalo ushlucho shel adam kemoto, and especially if they're your proxies, we know that a person's proxies are pinned back to the individual. Ve'afal pi she'en shliach lidvar avera, And even though you could argue, but if he's doing an Avera, he can't be considered my Shaliach, because we have a principle that a person doesn't do a crime as a Shaliach of somebody else, right? In other words, in Judaism, if I hire a hitman to kill somebody, I can't be convicted of murder in Jewish law, because there's a principle of ein shliach lidvar avera. I may be chayiv b'dinei shamayim, may be chayiv in the heavenly court, but I'm not going to be held liable for a capital offense. And the same thing is true. No, I think in Israel it's different. Israel is not governed by the strict letter of Torah law, because we don't require shnei edim, we don't require hasra'ah. There's a lot of things that Israel goes above, or halacha. I'm just saying that if a person is, there's this argument to be made, just because I'm paying these guys to do something which may be against halacha, why is it pinned on me? Ein shliach lidvar avera. That's the argument. Kol makom kol hatam bazeh mishum shomrim l'shliach divrei harabit divrei hatalmid divrei mishomim. But that's only because there's an assumption that no one's going to do an avera when he knows it's an avera for the sake of another person. Because he's going to listen to Hashem before he listens to another person. And that's the reason why we say ein shliach lidvar avera, because we essentially say, why would you listen to me over listening to Hashem? The fact that you decided to do the crime, therefore, means it was your decision, not because I told you to do it. That's the argument of ein shliach lidvar avera. That I can't, you just because I incentivized you to do an avera doesn't mean that it gets back to me. You knew what you were supposed to do. You knew what you weren't supposed to do. So it's your autonomous action, and therefore it can't be sort of traced back to me. Aval im hashaliach am haaretz v'lo yodea et ha'isser v'hu shogeg. But that's only true if the shaliach knows halacha. But what if the shaliach, is Itzik? And, I asked him to go ahead and climb up to the guy's merpeset and go get his big screen TV and lower it down with his cousin, right? So, if that's the case, he's an Am Haaretz. He doesn't know halacha. He figures, I'm getting $1,000 to do this, or a few $100 to do this. Let me go ahead and do this. Yesh omrim delo omrim bazeh ein shliach lidvar avera. So then, you don't say in that kind of situation, ein shliach lidvar avera. There's no such thing as it being pinned back upon the dispatcher, because the dispatcher is exploiting the person's ignorance of halacha, and that's not right. Amnam legabe ha'isser shel halicha le'erkos she'olaf nemar shu merim yad b'toras Moshe Rabbeinu nira she'ein kan. Oh, but okay, so it's one thing to hire a private guy to go ahead and do something that's against halacha in order to collect your debt. What about going to court? Can I go to court to collect the debt when a guy wrote me a check and the check bounced? So there you don't have to go to Beis Din, says Rav Sharaga. And I've said this to people before. If there's a clear promissory note that the guy owes you the money and he just check bound, with check is a promissory note, or any other kind of note on a debt, there's no isser to go to court. Kevin shehem lo danim al hachov v'lo uskim b'shem bishum birur ovadati. He says, because the court is not there to deliberate as to whether there's a debt or not. It's clear as day that there is a debt that has not been paid. Rak mevatzeim et hageviyah. All the court is there to do is to authorize the collection. Umikol makom mishar ha'isurim yesh bazeh baya. But you have to make sure that the court is not going to use aggressive tactics that are in violation of halacha. So when it comes to going, like if you, you lend a guy money, or he writes you a check for goods that he purchased and the check bounces. You call him up and you say, what's going on here? He says, well, I don't really like the goods, but but you took them, you used them. Yeah, but I've decided I shouldn't have to pay you. What are you nuts? I'm taking you to court. He says, you can't. I'm from a yid. You got to take me to Basin, right? A double chutzpah, right? So the response to that is, no, I don't have to take you to Basin. You signed the invoice. You committed yourself to pay for the goods that were delivered to you on such and such a date. There is nothing unambiguous about the fact that you owe me money. There's no Basin needed to clarify what my rights are as a creditor. I'm taking you to small claims court or whatever court I'm taking you to. And I'm also going to sue you for whatever court fees there are because I'm just so, this is so outrageous what you're saying. So, therefore, and now, by the way, this is an important thing is that there are certain times when going to a Basin is not required. If it's clear as day, and I actually use this argument to clarify a point, when the shul had contracted the services of somebody, and the person simply just and it was very, very clear in black and white that there was a monthly payment that was due, and the person just stopped making payments. So I argued shul shouldn't have to go to a Basin. He went to a Basin anyway, just because it didn't. Just the optics would not have looked good. But my argument was, why do you need a Basin for this? It's black and white. The guy owes us this and this amount of money, and he just has decided not to pay. Just yeah, it has. If it's clear cut, go to Basin. Now you're right. Sometimes cases can get complicated, right? And if he says I'm not paying you because you failed to address this, and this, right? And there's two sides, so then it has to go to a Basin.
Fighting, based in on one, I want for him, and then he refused to pay. So then
He refused to pay after the Basin ruled.
The Basin ruled. So what we did was arbitration, whatever agreement, took the Basin's judgment, made it a court order, and then filed it with the court. It became a Superior Court of Ontario judgment. Then we issued a garnishing order from the court and hit his bank account. We found the money in the account, and the bank paid the entire debt.
Wow, look at that.
Yeah. You could have garnished his wages, you could have garnished his debt, or got the sheriff or whatever. A garnishing order cost, I don't know, a few $100. Served on the branch where the guy had a bank account, happened to have the money in his deposit account. The bank closed it, paid the whole thing. So,
How much were we talking about?
I think it was a couple $100,000.
Wow.
Hit his account on it. At the time, the guy said, partner, said money would be in the account. Served the bank manager with the initial partner. It hit, phoned him up and said, did you get it? He said, yeah. He said, the money? Yeah. Frozen. Okay.
They won't tell you what's in bank account anymore. There's privacy acts.
No, they don't tell you, but if it's hit there, the law is that third party that owes the debtor money now must pay that money into court. That's the garnishing. So that was going to have to end.
Because they were part of it.
He knew that. Yeah.
They read the corporation. The guy who didn't pay their, even though they basically it's in their.
Oh, it's an Isser Deoraisa. Yeah, he's a Ganav. He's a Ganav. He's literally a Ganav. You can call him a Ganav. You can call him a Russia. These
Insurance company, like an insurance policy for people who owe you money.
So that's interesting. Okay.
It's an insurance policy, and if they don't pay within 60 days, I have to report them to the agency.
Okay.
And if they don't pay, they go after them on my behalf.
And if they still fail to collect
They'll
it,
sue them.
Right, but,
And they'll pay me.
but ultimately, they have to pay you, whatever the guy
Yes.
didn't pay.
Yes.
Have you ever relied on it?
Happen all the time because they do their work and they won't insure these people that
Right.
you're selling to unless they know that they're.
Oh, so
legit.
the holder of the policy is not you, the holder of the
It's
policy.
really, it's the insurance company, I pay them a policy, I pay them a premium, a large premium. And if something goes wrong, they get the money goes to the bank and the bank pays me, because the money is always,
So you're the policy holder.
yes. But it's a whole route of how it goes, it doesn't come directly to me, it goes first to the bank, who is insured, who owns my receivables.
Let's talk about this tomorrow.